Hello and welcome to Mississippi Insight. I'm Byron Brown. Thank you for joining us. We're digging into legal affairs this week. The state of Mississippi faces 2 lawsuits challenging the constitutionality of new laws aimed at curbing Jackson crime. Then there's the legal tussle over a widely used drug for medical abortion. Divergent rulings by 2 federal judges have moved the debate to the U.S. Supreme Court. We'll get expert analysis this morning from constitutional law scholar Matt Steffey. Also, people in Pearl tip their hat to an alderman who's stepping down to continue his fight against cancer. We'll hear from James Thompson and a man who wants to replace him this Sunday morning on Mississippi Insight. It was no surprise when legal groups and advocates for Jackson residents filed suit against HB 1020 and its counterpart SB 2343. Republican state lawmakers authored this bill as their response to rampant violent crime in the capital city of Jackson. It was last week when we told you about Governor Reeves' signing of these 2 bills on April 21st, and it was just a few hours later when the NAACP filed suit against new laws in U.S. District Court. The bills not only expand the jurisdiction of state-run Capitol Police, 1020 in particular sets up new criminal courts in Jackson's Capitol Complex Improvement District. Those courts would overseen by 4 judges appointed by State Chief Justice Michael Randolph. Jackson voters would have little or no say in those appointments. Then, last Monday, legal advocates filed a second suit in state court. Who better to discuss constitutional issues than Matt Steffey? He is professor at Mississippi College's School of Law in Jackson. Matt Steffey, welcome back to Mississippi Insight.
Thanks so much for having me, Byron.
Matt, let's just break down these lawsuits one at a time. First, the NAACP suit. Remind us what the plaintiffs are arguing in federal court.
Well, the federal court theory is that these bills, in combination and separately, violate the Equal Protection Clause of the U.S. Constitution, part of the 14th Amendment. Specifically, that they are tainted by race discrimination, that they have the purpose and effect of legislating with race in mind, on the basis of race, although not explicitly, which makes the order of proof very challenging. But the optics of the bill, as we've watched, were either overwhelmingly or exclusively white Republican majorities passing laws without the input, much less the support, of the African American members of the legislature from the city of Jackson, from the area most affected, and enlarging the district in a way that is reminiscent of racial gerrymandering familiar to anyone who has studied constitutional history. So the optics of it look like this was done by white politicians, at least in part, with the racial identity of the new CID in mind. Now, that's the allegation, anyway, of the NAACP. Alleging something and proving something to the satisfaction, ultimately, of the judges in the Fifth Circuit is a very different matter.
With the suit in Hinds County Chancery Court, you have Mississippi Center for Justice, the ACLU of Mississippi, and the MacArthur Justice Center and Legal Defense Fund challenging HB 1020 on state constitutional grounds. What is their argument?
Their argument is that by setting up a separate, in theory, temporary court system within the jurisdiction of the city of Jackson, but without involving the voters of the city of Jackson, and essentially doing an end run around the voters of the city of Jackson, the lawsuit alleges, they have violated the state constitution, which provides that, as we all experience regularly when we go to the ballot, that we elect everybody in Mississippi. And that certainly includes people who are going to preside over the kind of criminal cases that these courts will see, that are in charge of police, that investigate these matters, and district attorneys who prosecute them. But the key allegation is that these courts will serve very much like circuit courts, and the Constitution clearly provides that circuit courts are elected positions in the state of Mississippi. Now, the bill's attempt to negate that argument, negate that challenge by styling them as somehow temporary or inferior courts, it'll be up to this lawsuit to determine whether that's essentially putting window dressing on what's an end run around the Mississippi Constitution. So the lawsuit by the NAACP is in federal court based on the federal Constitution's Equal Protection Clause that forbids race discrimination, and the lawsuit by the Mississippi Center for Justice and others in state court is based on violations of the state constitution.
Do we have any sense of timelines here, or whether one or the other court may suspend these new laws in the interim?
Well, that's a very important question. And I think that depends on who the judge is that hears them and how these proceed. I think that's a big ask. It's always a big ask to go into court and say, this law is so constitutionally deficient on its face, it can't go into effect. It will cause some sort of irreparable harm. That's all. The scales are always tipped against that. It is certainly what the plaintiffs will ask for. Whether they get it is far from certain. I think these cases will start to see motion practice, that is a motion to dismiss on behalf of the defendants within the coming weeks. If those are unsuccessful, I think we will see these suits proceed in the coming months. I do think they will proceed sooner rather than later, but they could drag on for a matter of months at the trial court level, and then there's appeal. It is also possible that after legal rulings, for example, in the state court lawsuit, that the defendants will try to have the case taken on an accelerated basis, what's called an interlocutory appeal, a middle of the case appeal to the Mississippi Supreme Court, because the defendants correctly believe that the Mississippi Supreme Court is likely to be a friendly conservative thing. That's at least their strategic expectation, I think.
And because these lawsuits are both in federal and state court, the plaintiffs believe that they have a better chance of maybe getting something to happen because they're fighting in two different courts?
I think so. It's also the case that the Mississippi Supreme Court, and only the Mississippi Supreme Court, has the last say on whether something violates the state constitution. And so that case really has to be diverted to state court. While the federal claim could be brought, an equal protection claim in state court, I do think the idea is this multiplies the chance of success. That what the plaintiffs need is one judge willing to block the law, one judge willing to give it a full hearing on the merits, and the objective of keeping this law from going into effect would be achieved.
Well, let's move on now to the debate over mifepristone. It's part of a two-drug combo that accounts for more than half of all abortions in the U.S., according to the New York Times. A federal judge in Texas ordered the drug off the market, saying that the FDA improperly approved the drug. The Biden administration appealed and finally won a Supreme Court decision to maintain the status quo for now. What do people need to know about this legal debate and how it might eventually be resolved?
Well, the interesting thing about this legal debate is how fast it got to the U.S. Supreme Court. We have dueling lower court rulings, and that's just the sort of thing that invites the U.S. Supreme Court to intervene so that the law is uniform across the country. Lawyers are strategic thinkers, if they are anything else, and the lawyers challenging mifepristone found perhaps the one judge in the United States of America, a new to the bench, newish to the bench, an appointee of President Trump, most willing to issue nationwide injunctions against policies passed by the Biden administration. So it was almost a foregone conclusion in the mind of observers that the Texas judge would issue this ruling. This drug has been in effect for a very long time and through a tremendous amount of safety data. And so it's kind of an unusual and not particularly conservative position to ask a single judge to second guess the entire scientific judgment of the FDA and others. So I think this has, in the U.S. Supreme Court, a very interesting dynamic. You have a court that has clearly held there's no constitutional right to abortion. You also have a court that has been more hostile to executive agency action. On the other hand, this court does not want to invite constant second guessing of drug approval. I think it is, for those who want to preserve access to this drug, it is promising that the U.S. Supreme Court has issued an order allowing the drug to continue to be dispensed and sold while it's deciding the case. That is no guarantee of how the case would come out. But had it been otherwise, had they allowed the ban to take effect, it would have been grim news for abortion rights advocates. But I think what we need to realize is that for probably the rest of this year, this drug will continue to be available because the Supreme Court has allowed it to, has put the Texas judge's ruling on hold and decided to take the case. We would expect that case to be heard and decided no sooner than sometime near the end of the year. So for now, we have the status quo. In the long run, this could be enormously consequential. There's also a secondary legal issue lurking out there that the drug has another approved purpose. And once a drug is approved for any purpose, doctors can use it for off-label uses. And so there's a back channel to this that, although not an important component now, could become important down the road. This will get wrapped up not so much in abortion issues as in issues of administrative law and the science of the Food and Drug Administration.
And how
for now, status quo.
And how important is it? That's been the debate on the Biden administration side, that if they do overrule this, that everything that the FDA approves could be under scrutiny from this going forward. Do they have a...
Absolutely. No, the Biden administration is right about that. If the court is going to be not a court of law, but also a court of drug approval, it's a groundbreaking change in the delivery of medicine and medical services in the United States. And so if there's a ruling unfavorable to this drug, I have no doubt it will be crafted as narrowly as possible and in a way that doesn't invite that. But on its face, it certainly does. This is not a new drug. This is not a provisionally approved vaccine. This is a drug that has been used by millions and millions with a great safety profile. And normally, we leave, in our structure of government, those decisions to the agency experts and the doctors and their patients. This would be a crippling ruling to early-term abortions across the country if the Texas ruling were allowed to go into effect. This is the most common route of abortions, particularly early, which is when most happen. And it could really change the landscape and further balkanize or create two countries within a country, few states where abortion remains legal and a great desert of access to those services in the meantime. So I think this is medically complex. I think it's legally complex. I think the court's going to take its time and either defer to the FDA or craft some narrow ruling that keeps this controversy going for years to come.
Mississippi Attorney General Lynn Fitch is among more than 20 Republican AGs supporting restrictions on this abortion bill. 18 Democratic AGs oppose those restrictions. What do you make of the politicalization of these key legal debates that we have going on?
Well, I think fundamentally it's all politics, including going to a rather remote area of Texas that I'm the judge most willing in the United States of America to step in and put a halt to this drug. Again, we don't normally expect the Attorney General, as competent and qualified as she is, to be an expert on the medical delivery of these services. The question will be our political willingness to listen to doctors, our political willingness to allow women to make these decisions for themselves, or whether this is another salvo in the culture wars. Right now, it's shaping up that way. And I'm not sure that the further politicization of this, the further stark dichotomy helps the case when its FDA approval not the general policy on abortion.
We want to get your take now on some new polling on the Supreme Court. A Marquette Law School poll last month found that a 55% majority of Americans disapprove of the nation's highest court. Then a poll by the Economists and YouGov finds about 3/4 of Americans want justices to be required to disclose any gifts that they receive. This all follows revelations about Justice Clarence Thomas taking lavish vacations while a Texas billionaire paid the bill. Should Americans be more concerned about accountability at the high court?
Absolutely. Americans should be concerned about accountability at the high court, accountability at circuit courts, accountability at district courts throughout the federal judiciary. These, under our constitutional system, are judges that serve for life. And they have very little in terms of oversight and accountability, except what they invest in their reputation. The Supreme Court has nothing if it doesn't have public approval. Not long ago, in the 2000 Bush versus Gore election, the Supreme Court was held in sufficient esteem that the country accepted its judgment, largely without question, giving the state of Florida and the election to President Bush. It is hard to imagine the court having the stature to do that today. I see a difference in the attitude of my students. Law professors are fond of saying, what the law says is not the most important thing. The most important thing is who decides. And to whatever extent that's true, it is critical that we have confidence in the integrity of justices. We have confidence in the integrity of judges. We expect them to have ideological differences, but we also expect them to be free of influence.
Do you think that something's going to change on the court where we'll see some more restrictions or some more accountability there?
I hope so. It's largely have to come self-imposed. There are some federal statutes that are potentially in play. I hope so. I think so. Chief Justice Roberts is the person most concerned with the institutional integrity and reputation of the court. I think he'll look at the tools at his disposal. I don't think this would be personal to Justice Thomas, but rather measures designed to be more transparent and accountable. I hope that happens, because while there are other ways we could have a Supreme Court, for example, there have been suggestions over the years that rather than sitting on the Supreme Court for life, that the Supreme Court is selected periodically at random or by some other means from lower federal court judges. There are countries that do that. There are scholars that think that would be worthwhile. None of that change is on the horizon. The only change we are likely to see is the change that Chief Justice Roberts can bring about. He would need consensus and support to do that. I hope it's coming.
Matt Steffey, professor of law at MC School of Law, thanks again for joining us here on Insight.
Thank you for having me.
All right, and we'll be right back. The Pearl Board of Aldermen recently honored a fellow colleague stepping down from a seat to focus on his battle with cancer. 12 News' senior political correspondent Richard Lake sat down with Ward 5 Alderman James Thompson to learn more about how he has served the city of Pearl.
James Thompson began his career of public service over 30 years ago, starting his 25-year career in the Pearl Police Department in the late 80s. Thompson then made stops in the Mississippi Department of Education and the Madison County School District before finding himself running for public office.
I've never been involved in politics, although I like talking the game, I like hearing all the ins and outs. So I just made a decision. I said, I live in 5 and I still got more to give to the city where I was raised. And so I took a shot in the dark and decided I would run for alderman.
Thompson was elected in 2017 as the first independent candidate ever elected to the Pearl Board of Aldermen, a distinction Thompson is proud of and one that shaped his tenure.
If you're fighting for the common goal of the people, it doesn't matter what party you're affiliated with as long as you're doing the right thing.
Alderman Thompson stepped down from his seat to continue his battle with cancer on April 18th. Dwight Knight, a friend and Ward 5 candidate, says Alderman Thompson didn't just view his role as a part-time job.
It means something to him. It's not just a job. It's not just a position. It's something that he saw that needed to be done, and he was willing to step out and do it, and I think he served us admirably.
Alderman Thompson's message to residents of Pearl: get involved.
The more people you have involved, the better off, in my opinion, the city is. Because there's a lot of things that are going on that people don't know about. The only way you can know about it is to be involved.
Reporting in Jackson, Richard Lake, 12 News.
If you have comments or questions about today's show or suggestion for an interview or segment, just drop us a line. Email our producers. The address is news@WJTV.com. Big thanks to Matt Steffey for joining us this week. We'll be back next weekend with more of the political and current affairs coverage that you demand. I'm Byron Brown. From all of us here at 12 News, make it a great weekend.